The boycott, divestment, and sanctions movement leads a coordinated effort to harm the economic and financial stability of the State of Israel. The movement seeks to coerce companies to either end engagement or refuse to engage in commercial relations with Israel, its nationals, and its residents. The clear goal of the movement is the elimination of the State of Israel. And through cultural and academic boycotts, the BDS movement also targets people who are Jewish. Now, some 35 states in the US have adopted state legislation countering BDS, many with broad bipartisan support, and some setting an example which has been followed in other countries. Dr. Mark Goldfeder is an expert in the subject. He is the director of the United States National Jewish Advocacy Center. He's served as the founding editor of the Cambridge University Press series on Law and Judaism, a trustee of the Center for Israel Education, and as an advisor to the permanent mission of Israel to the United Nations. Dr. Goldfeder has taught law internationally as senior lecturer at Emory University School of Law and served as a senior fellow at the Center for the Study of Law and Religion, director at the Restoring Religious Freedom Project, and a visiting professor at many other universities in the US, Italy, and Israel. Dr. Goldfeder handles religious discrimination, anti-Semitism, and BDS cases around the United States, and lectures and writes widely on these topics. He is a leading expert on counter-BDS legislation in the US, and we are truly privileged to have you with us. Ladies and gentlemen, please put your questions to our speaker into the Q&A facility, and I will be putting as many of them as possible after an initial overview of the developments in this anti-boycott legislation. Dr. Goldfeder, over to you.
Good afternoon, everyone. Can you hear me?
Loud and clear.
Okay, great. First of all, I want to thank UK Lawyers for Israel, Natasha, and the Turners for this invitation. I'm very happy to be here with you and to talk a little bit about anti-BDS statute in the United States, their background, their First Amendment, and some of the false narratives that have sprung up around them. I have a presentation I'm going to share with you, and it actually gets a little bit interactive in a few minutes. So there will be polls periodically popping up on your screen. Here's the truth. I don't like when people just tell me things and ask me to accept them as true. I want to actually walk through the analysis with you and make sure that we're all on the same page. And so at every point where there's a sort of step in the analytical process, I'm going to stop. I'm going to ask you a question. You can answer it, and we'll see how many people are on the same page about how the legislation works. All right, you'll see what I mean once we get started. I'm going to share my screen now. Okay, can everyone see that?
Yes, we can. Thanks.
Okay, great. So just to give you a little bit of a background, as Natasha started doing, the majority of states in the United States, 35 states as of now, have adopted these so-called anti-BDS bills. And the motivation behind them was the rise of the anti-Semitic boycott, divestment, and sanctions, or BDS, movement. And again, the first mistake that people make is not taking BDS seriously. It's very easy to forget that when the Nazis came to power in 1933, the first governmental action against the Jews of Germany was the boycott of Jewish businesses. And so conversations like this are incredibly important for us to be having at every stage. Now, one of the stated goals of the BDS movement is to pressure Israel to comply with international law. Another is to bring about the end of Israeli occupation. We could talk for hours about why Israel does comply with international law, why Israel is not an illegal occupation under the Geneva Conventions. But for the purposes of today, I want to focus on some of the other goals, because some of the other goals of BDS, some a little bit more explicit, some less, are to bring down the state of Israel. Okay, and that is where you start heading into problems of invidious discrimination. In 2015, Congress also heard testimony from former U.S. Treasury terrorist analyst Jonathan Schanzer about the significant links between a number of major American funders of the BDS movement and Hamas and some other designated terrorist organizations. Why that's important is because there's an entire separate angle of fighting BDS, which focuses on these terror ties and the inability of American institutions under a Supreme Court case called Holder to support terror. But we're going to leave that aside for now, and we're going to talk just a little bit more about the First Amendment and how it applies to anti-BDS statutes. So, and again, in response to the movement, 35 states have enacted these bills, and the most common claim that you hear about these bills, at least in the United States, I don't know if it makes its way across the pond, is that they somehow restrict the kind of free speech that is protected by our First Amendment. Again, the First Amendment free speech clause is one of the foundational bedrocks of our Western democracy, right? Even hateful speech can and should be protected in order to make sure that thoughts can be shared and debated publicly. But there is a difference between free speech and crossing that line into discrimination, and that's what we're going to talk about today. So I don't know how many of you have actually seen an anti-BDS bill, and I put up for you what is the South Carolina bill, because it's an excellent model, and a lot of them are based off this bill because it was the first one. And I want to actually just take a couple of minutes to read it with you, because it's really important to see it inside before we can talk about what people say about it who probably haven't even read it. Okay, so let's read it together. There's a prohibition of contracting with discriminatory business. A public entity may not enter into a contract with a business to acquire or dispose of supplies, services, information, technology, or construction, unless the contract includes a representation that the business is not currently engaged in, and an agreement that the business will not engage in, the boycott of a person or an entity based in or doing business with a jurisdiction with whom South Carolina can enjoy open trade, as defined in this article. For the purposes of this section, boycott means to blacklist, divest from, or otherwise refuse to deal with a person or a firm when the action is based on race, color, religion, gender, or national origin of the targeted person or entity. A boycott does not include, and these are important, we're going to come back to some of them, a decision based on business or economic reasons or the specific conduct of a targeted person or firm. Boycott against a public entity of a foreign state when it's applied in a non-discriminatory manner, or conduct necessary to comply with applicable law in the business's home jurisdiction. We're going to break that down, but I wanted to just read it with you, because the very first question I want to ask you is, what does this bill do? Okay. Does the South, and you should have a poll popping up on your screen so we can see it together. Does the South Carolina bill either prohibit or prevent any individual or individuals from exercising their own free speech rights? While you answer that question, I'm going to go back a screen so you can read it while you're answering it. I'll give you about 10 seconds to answer that question. Does it prevent, this is poll 8 that popped up on my screen. I don't know if there's, Caroline, if there's poll 1. Okay, well, the first poll question was, does South Carolina bill, here we go. All right, take 10 seconds to answer that question. Now let's do the second question. Does the South Carolina bill infringe on any person's freedom to invest their own money as they see fit, including with, BDS related companies? Poll number 3. I told you it was going to be interactive. Does the South Carolina bill that we just read together bar the state, the public entities related to the state, from contracting with any business that boycotts others based on race, color, religion, gender, or national origin? Okay. Again, while you're answering these questions, just take another quick look back at the bill. I'll see this together. And if you look at section A, I'm trying to just give you a little hint here for those who may not have answered them yet. A public entity may not enter into a contract. Okay, let's take a look at some of the answers, right? Here are the answers. The South Carolina bill does not prohibit or prevent any individual from exercising their own, most of us are on the same page. Okay, for those of us who aren't, let me just go over it again. It applies to public entities, right? It doesn't prevent any person or individual from exercising their own free speech rights or investing their own money as they see fit, right? That was the answer to the second poll. They can do whatever they want. All it does is protect the interests of South Carolina and the United States, and it removes the state's funding for discriminatory action. What do I mean by protect the interests of South Carolina? South Carolina and the US, well, South Carolina does tens of millions of dollars of business with Israel and would stand to lose quite a lot of money if companies started engaging in BDS. The United States does billions of dollars worth with Israel and would lose tremendous amounts of money. So it is entirely in South Carolina's interest. It's a business decision for South Carolina to a certain extent to say that, hey, we're not going to do business with companies that are going to require us to lose potentially massive contracts. And surprise, states aren't required to support BDS. It's absurd to think that they'd be required to support it. Governor Cuomo, after he signed Executive Order number 157 in New York, which was their anti-BDS legislation, said, as a matter of law, there's a fundamental difference between a state suppressing free speech, right, which applies to individuals, and a state simply choosing how to spend its own money. To argue otherwise would be to somehow suggest that New York is constitutionally obligated to support the BDS movement, which is not only irrational, it has no basis in law. Okay. In case anyone is not super convinced, though, I want to dig a little bit deeper and go through the analysis again together. Okay, let's take seriously the contention that people have that anti-BDS bills violate the First Amendment. In order to violate the First Amendment, two propositions would need to be established. Number one, the actions prescribed by the statute would have to be private speech, not government speech. And number two, the activity of engaging in BDS itself on the part of companies and institutions would have to be the kind of speech that's protected speech under the First Amendment. So, are the actions prescribed by the state in this model anti-BDS bill that I showed you prescriptions on private speech of individuals or on government speech? Right, yes, if it's private speech, no, if it's government speech. The answer is government speech. Again, that first line, it applies to public entities. When the government, there we go, everyone's on board. Good. I want to walk you along with me. It's important that we take every step seriously. When the government is deciding what it wants to say, that is government speech. It is not subject to the same First Amendment requirements. And we know this because the Supreme Court of the United States has said so many, many times, and they very recently confirmed it again. In 2015, it was a case called Walker versus Texas Division Sons of Confederate Veterans. I'm sure it was a big case here. I doubt that it made it international, but basically in Walker, a nonprofit organization brought an action against the Texas Department of Motor Vehicles, saying the government was violating its free speech by not allowing them to put specialty license plates with the Confederate flag on them. The Confederate flag in the United States is somewhat of a divisive symbol. Okay, the court concluded that the government had the absolute right to decide the message it wanted to display on its license plates. And they said, and I quote, I'm reading it now from the screen I'm sharing with you, as a general matter, when the government speaks, it is entitled to promote a program, to espouse a policy, or to take a position. In doing so, it represents its citizens and it carries out its duties on their behalf. Now you might ask yourself, hold on a second, that license plate, maybe that's the speech of the person driving the car. How do you know when you're dealing with government speech versus private speech when the line is that close? Hint, it's not that close in the BDS stuff. It's about government spending money, but we'll get there. The court says there are a few ways to determine whether it's private speech or government speech that you're dealing with. First, the medium is one which has long been used to communicate messages from the state. Number two, the medium is closely identified in the public mind with the state. And number three, the state maintains direct control over the message conveyed. Those are the three factors. Okay, so let me ask you this question. When the government decides to pass an anti-BDS bill, are they, and I'm quoting from the Supreme Court here, promoting a program, espousing a policy, or taking a position, which is their job to do? This could be yes or no. So if you hit let's just say if they're doing their job, take the third one, taking a position, which is their job to do. The answer is yes. When states enact they're doing all three. Yeah, all three of those are sort of the same thing. Promoting a program, a policy, or a position, all the same thing, which is their job to do. So everybody is still right. When states enact anti-BDS bills, that's the government taking a position on an issue, which is its job to do. In fact, it's exact same issue as the state was talking about in Walker, which is a position that distances the state from a potentially divisive, harmful, or hateful speech that directly opposes its own social and economic values. In Texas, they didn't want to put up Confederate flags. In South Carolina, they didn't want to support BDS. That's the government taking a position. Okay, poll number 6. Do we have any or all of the government speech factors that are outlined in the Walker case? So, is the medium one which has long been used to communicate messages from the state? Is the medium closely identified in the public mind with the state? Does the state maintain direct control over the message conveyed? And again, the answer is if you pick any of these, you're correct. Because there are fewer things that a person could imagine that are more tied to a person's belief than where they choose to spend and invest their money. And that is true for the government as well. It should be non-controversial. On the screen, I brought you some Supreme Court cases that say that explicitly. When the government chooses where to spend its money, that is definitionally government speech. So the government is speaking via a medium, its funding, that has long been used to communicate messages and that the public associates with the state, because people are familiar that when the government spends money on a project, they're supporting that project. Okay, let's go to that third factor. Does any other entity outside of the state and its various bodies exercise control over the use, allocation, and investment of public money in the state? Or is it the state deciding what to do? The answer is no. No one else but the state decides where to spend its money. So you actually have all three Walker factors. When the government takes a position by passing an anti-BDS bill that determines where it will spend the state's money, that is government speech. Now, again, that, by the way, should end the entire conversation because that's the first requirement in order to violate the First Amendment would have to be private speech, not government speech. We've just conclusively walked through why it's government speech according to the Supreme Court. But in case there are follow-up questions, I want to take all of them seriously. So the first question people have is this. I get that the government can choose not to get involved in a divisive issue like BDS, but are they really allowed to actually get involved by being anti-BDS? Isn't that a problem of viewpoint discrimination, of the government discriminating against those who do like BDS? And the answer, I'm glad you asked, is no. But the longer answer is still no, and that comes from, again, a variety of cases, but we'll stick with Walker because for ease of purposes. When the government speaks, it is not, this is basically as clear as you can get, it is not barred by the free speech clause from determining the content of what it says. And this has to be true, or else the government could not function. Were the free speech clause interpreted otherwise, government would not work. How could a city government create a successful recycling program if officials, when writing householders asking them to recycle cans and bottles, had to also include in the letter a plea from the local trash disposal enterprise demanding the opposite? How could a state government effectively develop programs, very apropos for today, designed to encourage and provide vaccinations if officials also had to voice a perspective of those who oppose this type of immunization? It would be impossible for government to run, and therefore the court says we have refused to hold that the government unconstitutionally discriminates on the basis of viewpoint when it chooses to fund a program that is dedicated to advance certain permissible goals, just because in advancing those goals, it necessarily discourages alternative goals. Okay, so there's not a problem of viewpoint discrimination. And here's where people get a little bit more fluffy. They say, I get it. I get that it's government speech, fine. But it does implicate private speech because the government is saying, we won't speak to you if we don't like your private speech. So it does implicate private speech. Is that a problem? And this one we didn't really cover yet. We're about to, so I'll preview it. The answer is no, it's not a problem. And again, I'll give you the short version here. The Supreme Court has held multiple times that government speech may, and I quote, implicate the free speech rights of private persons. And even in cases of government speech, theoretically, you're right, the First Amendment does limit a state's authority, but only in a certain way. The state cannot compel a private party to express a view which the party disagrees with. But again, that's not what's happening here, right? For example, in Walker, right? The government didn't force any citizen to convey a specific message on their cars. They just said, you can't put this message on your cars with the Confederate flag. Exact same thing here. The anti-BDS bills are not compelling anyone to say anything. All they're saying is, if you engage in BDS activities, as is your right, we have a position that is contrary. And that's entirely acceptable under, again, Supreme Court jurisprudence. Okay, so again, if this is a prescription on government speech, not private speech, shouldn't this conversation be over? I mean, that was literally the first criteria we said it would have to be private speech. The answer is yes. It would be a very short class. The conversation should be over. Anti-BDS statutes don't violate the First Amendment because they constitute government speech and not private speech. But let's just play the game for a little bit, just for kicks, okay? Even if it were necessary to go to that second proposition, that anti-BDS statutes also don't violate the First Amendment because the actions prescribed by them do not constitute protected speech. So the case that is often brought up by BDS proponents is a case called NAACP versus Claiborne Hardware. Okay, that case said the following: boycotts have long played a significant role in US history, and the Supreme Court has held that boycotts to affect political, social, and economic change are protected by the First Amendment of the Constitution. That was a case that involved the Black community boycotting certain discriminatory white businesses. And there are many, many reasons why Claiborne is completely inapplicable to BDS. I mean, it's literally the opposite of BDS, but because we have limited time here, I'll just stick with some of the main ones that deal directly with the BDS movement's false assertions. So, are all boycotts created equal? And do all boycotts have all of the same First Amendment protections? And this, because we're not all an American audience, I'll help you with that. The answer is no. And here's what you find interesting, because when you read the briefs and the legal filings from the BDS proponents, they don't like to talk about this, okay? BDS supporters, either they don't want you to know this, but a lot of them probably don't know it themselves. There are actually a variety of different kinds of boycotts, and I want to walk you through them, right? A primary boycott is usually defined as a boycott where the boycotter is acting against the entity that it has a grievance with. That would mean BDS supporters boycotting the state of Israel, okay? That's a primary boycott. A secondary boycott is where the party boycotting an entity has the goal of affecting a third party rather than the boycotted entity. So for example, BDS supporters that are boycotting companies that do business with Israel or are Israeli because they want to affect Israel. That's not a primary boycott, that's a secondary boycott. You're boycotting a third party, an entity to affect a third party. There are also tertiary boycotts, we'll get to that in a second, but what are BDS activists actually doing? So their issue appears to be with the state of Israel, but they're not engaged in just a boycott of the government of Israel. The majority of things being boycotted, whether it's individuals, companies, academics, etc., are not the state of Israel. They're just individual businesses. Now, there are some primary boycott aspects, but BDS is primarily a secondary, maybe even a tertiary boycott. So here's a great question, and it's going to harken back, see if you can remember. Do the anti-BDS bills, and think about the South Carolina one we read, prohibit primary boycotts or only secondary boycotts? The answer is, and I'll show it to you again because it's been a while since we looked at it. Hold on. I have to vote before I can move on here. Sorry, hold on a second. Okay. Let's read it again. It involves the boycott of a person or an entity based in or doing business with a jurisdiction with whom South Carolina can enjoy open trade. Boycott does not include a decision based on business or economic reasons, forget that, or the specific conduct of a targeted person or firm. What does that mean? It means that if you're boycotting a person, and a person here is also a judicial person, could be a state, if you're boycotting someone or something because of something that they did, a primary boycott, the anti-BDS bills do not apply, period, by definition. They only prohibit the secondary boycott aspects of the BDS movement. They do not prohibit primary boycotts, because a primary boycott, if you're boycotting the state of Israel, the entity that you hope to change, boycotts based on the specific conduct of a targeted person or firm are excluded by definition. So BDS bills only deal with secondary boycotts. Now, why do BDS supporters not like to talk about this distinction? Because secondary and tertiary boycotts have very little protection under the First Amendment, okay? The reason behind that is a deep constitutional reason, is because when you're doing a secondary boycott like that, you're not trying to protect your own constitutional rights. You're trying to use commerce to inflict harm on someone else. In fact, this is somewhat awkward, but that court in Claiborne, which was about a primary boycott, actually specifically stated that secondary boycotts and other actions that impact commercial activities can be prohibited. And I'll read it to you from the same case that they like to quote, but not fully. Secondary boycotts and picketing by labor unions may be prohibited as part of Congress striking the delicate balance between union freedom of expression and the ability of neutral employers, employees, and consumers to remain free from coerced participation in industrial strife. It's not fair, says the court, and this is what a secondary boycott does, to have you drag me into your fight with Israel. You want to boycott Israel? Go ahead, and the state will do business with you. It's fine. You just can't boycott others because they do business with Israel. And that only applies to secondary boycott aspects. Now, we'll go a little bit deeper on this, because this is where you really get into the nuts and bolts. There are some savvy BDS supporters who say, well, don't worry about that. All of our boycotts are primary, because the companies that we're boycotting, they themselves deserve to be boycotted because they're complicit in that horrible Israeli occupation. Okay. They'll say, for example, you know, we're not targeting them to hurt Israel. We're targeting them themselves in a primary boycott because they are complicit. Now, that on its face, that's ridiculous, right? A company like Sabra Hummus, right? Their complicity is that this Farmingdale, New York-based company is co-owned by the Strauss Group, whose website says that their donation program includes Israeli soldiers, and that makes them complicit in quote unquote war crimes. But regardless, let's take seriously their contention that this makes it a primary boycott. Do these complicit companies fall under the primary boycott analysis because the companies are complicit in the actions of the state of Israel? It's a complicated question. Think about it. Is that enough of a factor, do you think, to make them complicit and therefore a primary, not a secondary boycott? The answer is no. Okay, by the way, it also wouldn't matter if they were right, because as we said, there are a variety of reasons why this conversation should have already been over, but they're not right for three reasons, okay? First of all, BDS has official goals, and this comes from the Palestinian Civil Society Call for BDS, their manifesto, including ending occupation and colonization of Arab lands, recognizing the fundamental rights of equality, respecting and protecting and improving the rights of Palestinian refugees. Allied doctrine in boycott law tells us that if the second party being boycotted doesn't have the power to resolve the underlying claims, then they cannot be considered part of the primary boycott. Okay, so let's just take a look again at those goals of the BDS movement, right? Hold on a second. Ending occupation, recognizing the rights of Arab Palestinian citizens, promoting the rights of refugees. Question for you. Does SodaStream, for example, or Sabra Hummus have the power to change Israeli policy and end occupation? No poll for this one. The answer is they do not, which means that under the Allied doctrine in boycott law, they're not part of the primary boycott. Okay, number two, it's a pretty clear test. The BDS folks are actually pretty open about why they're boycotting their companies, and it's not really about the companies at all. It's about trying to affect and to harm Israel. In the BDS manifesto, there's 15 pages of analysis that call for a global attack on Israel's commercial interests, not its complicit companies, Israel's commercial interests, by building a movement that will create effective pressure and impact and isolate the Israeli economy as a whole. So it's not just about affecting Israel, it's about affecting, it's not just about affecting these complicit companies, it all harkens back to trying to isolate Israel. That is explicitly the reason, again, why they're pressuring companies. So, for example, the BDS called for a boycott of the cell phone company Orange, and they forced Orange to leave Israel. They weren't boycotting Israel directly, but it also really wasn't about boycotting Orange, right? They're boycotting someone else to hurt Israel. And they do that with a lot of companies. And the question you ask yourself is, if Israel wasn't there, would they still be boycotting it? If the answer is no, you're not part of the primary boycott. Okay, that really is reason number 3. Even if they did want to also boycott a company like Orange for being complicit in Israel's actions, courts have held that when boycotts are motivated in whole or in part by the desire to advance a defendant's interests in their primary dispute with the primary boycott, the second party would not have been independently boycotted. That's called a secondary boycott. So even if they're also primary boycotts, if part of what you're doing is to affect your real primary boycott target, i.e. Israel, then that's considered a second boycott. Nobody thinks that BDS would be boycotting Orange if Israel changed its policies, which means that Orange is secondary. And again, remember, none of this actually matters because to the extent that there are primary boycotts, the law doesn't touch them. Also because, the whole government speech thing. So again, and this is just an FYI, where I know we're running low on time, want to get to questions, so I'll try to hurry it up. But what we actually see in practice on campuses across the country is Jewish, not even Israeli, Jewish students and organizations are being punished and boycotted and threatened and fired, and their complicity is in being Jewish. Remember Matisyahu a few years ago, a Brooklyn-born singer, BDS tried to get him thrown out of a festival in Spain. What was his complicity? He was Jewish. Okay, by the way, before we end off, there's a different Supreme Court case called Longshoreman versus Allied International. It was decided the same term as Claiborne. That's actually the controlling case regarding BDS activity in the US. In Longshoreman, the court held that prohibiting secondary boycotts that are directed at a matter covered by US foreign policy does not infringe First Amendment rights. So we'll finish up soon. Bottom line, are governments allowed to regulate secondary commercial boycotts? Give you a couple seconds on that one. Yes, they are. Explicitly, Longshoreman. And therefore, based on all of the above, the fact that government speech, not private speech, they don't target primary boycotts, they only target secondary boycotts. And the Supreme Court has pretty explicitly said you can regulate secondary boycotts. Are anti-BDS bills constitutional? Hope we get the short answer is yes, they are. Okay, and again, participation in BDS is not protected speech, it's a secondary boycott. And truth be told, these laws actually regulate government speech, not private speech at all. Nothing in the anti-BDS laws, or suggested here today, prevents any American from protesting against Israel or engaging in individual primary boycotts of Israeli goods, but that's just not what's happening. So when people engage in free speech you don't agree with, the proper response is counter speech. But when they set up illegal secondary boycotts that discriminate against the Jewish people and the Jewish state, like the BDS movement has done, then we have to develop the tools to stop them, and these BDS bills are one such tool. I'll end the presentation here. I can figure out how. And I'll turn it back over to Natasha.
Well, Mark, thank you very much indeed for that incredible overview. And thank you also to our audience for participating in the polling. I wanted to start by asking you how anti-BDS bills relate to other anti-discrimination bills in the United States. And we've had a question that I think follows on nicely from that, so I'll put it to you at the same time. Our questioner writes, in Fulton, the Supreme Court unanimously struck down Philadelphia's requirement that a Catholic social services agency certify it would consider same-sex and unmarried couples equally with married heterosexual couples. So how much room does this give a company to certify a non-discrimination provision?
So let me take a step back. It's a really good question. The idea behind these bills is that it's not one about Jewish supremacy in any way. It's about equality, and the same sorts of anti-discrimination mechanisms that are used across the board should be used when the discrimination is based on ethnicity or national origin. The Supreme Court has consistently found that state and federal anti-discrimination laws that are related to race, religion, color, national origin don't violate the highest level of First Amendment protections, and they basically found that again in Fulton. The reason is because states all have what's called a compelling interest in preventing invidious discrimination, and they're free to implement that compelling interest by imposing even conduct-based regulations on government contractors. Now, where it gets interesting, and to my point, and I'll give you my cynical view, hypocritical, liberal organizations, like, for example, the American Civil Liberties Union, have been very publicly supportive of this idea on a regular basis in a variety of contexts. And the only difference appears to me to be the relative popularity of the targets of the discriminatory action government is seeking to protect against. So, for example, I'll read to you, pull it up here for a second. Yeah, in a case called Arkansas Times, which is a recent BDS challenge, the ACLU filed on behalf of this newspaper and came out in support, arguing against the general rule that commercial decisions to buy or not to buy are not protected by the First Amendment. It's surprising because they're arguing against literally the very same rule that they have championed in other cases, like Masterpiece Cake Shop. I don't know if you all have heard of that case. That was one that involved a baker who didn't want to bake a cake in support of a same-sex marriage. And this is what they wrote in that case. I just pulled it up. The bakery is not the first business to claim a First Amendment right to violate an anti-discrimination law, and this court has never accepted that premise and has instead affirmed repeatedly the government's ability to prohibit discriminatory conduct over the freedom of expression, association, and religion objections of entities ranging from law firms to private schools, even, by the way, to newspapers, which is funny because representing a newspaper. The Constitution does not guarantee a right to choose employees, customers, suppliers, or those with whom one engages in simple commercial transactions without restraint from the state. And in fact, the ACLU said this is the general rule for all commercial activity. While the particular facts of this case involve a bakery refusing to sell a cake, arguments are not limited to here. It is possible to find some kernel of expression in almost every activity that a person undertakes. A wide range of businesses could claim a First Amendment exemption from generally applicable regulation of commercial conduct. To recognize the bakery's First Amendment objections would run counter to the basic principle reflected in over a century of public accommodation laws that all people, regardless of status, should be able to receive equal service in American commercial life. The state's prohibition against discrimination in the sale of goods and services to the public is a regulation of commercial conduct that affects expression only incidentally. Businesses, the court held, have no constitutional right to discriminate. That's exactly what we just proved with our previous presentation. And that is consistent with everybody somehow until you get to Israel. And they say, well, if you're discriminating against Israel, then you should be allowed to do it, and the state has no right to things. So how do they intersect? They intersect perfectly. They're based on the exact same principles. They should easily be applied. They use the same foundation of a wide range of anti-discrimination laws, and the only difference is who is being discriminated against. It's unclear to me why people don't see that.
You've mentioned a little about these challenges already, but there's been a lot written about the challenges to the BDS bills, especially in Arkansas and in Georgia. Are you able to talk a little bit more about those current challenges and what we might expect from them?
Sure. Some of those are a little bit technical. So let me give you just a little bit of a background again. So again, just by way of background, we talked about the variety of states, 35 that have passed it. Some of them have slightly different wording than the bill that we talked about. In some cases, the state, for example, put in the word Israel, right? The South Carolina bill said any anyone who the South Carolina enjoys friendly relation with. Some states are more explicit that they're trying to protect Israel, but just so there's no confusion, none of the state anti-BDS laws ban or punish speech that's critical of Israel. None of them target advocacy for Palestinian rights. None of them stop anyone from boycotting Israel. All of them simply say that if you do choose to boycott Israel, the state can choose not to do business with you. And again, by definition, we saw that the law only affects discriminatory commercial conduct, right? It doesn't, for example, affect decisions that are based on economic considerations. Now think about it. The only way you could possibly know that someone's buying decisions were based on discriminatory motives instead of economic reasons would be if they told you in accompanying speech, right? If you decide not to do business with company A, as an outsider, I don't know why you decided that. The only reason I know that you're doing it in a discriminatory fashion is if you tell me, oh no, this wasn't a business decision. We're discriminating against them because they support Israel. So certainly when BDS by admission, right, involves non-expressive discriminatory conduct, it can be regulated by anti-discrimination law. And as we said a second ago, it shouldn't be controversial, right? The Supreme Court has consistently held that state and federal anti-discrimination laws don't violate the First Amendment. So, by the way, another thing that comes up in these cases we already covered, to be fair, right? A casual observer might be confused by the term boycott. So a lot of these challenges start with, well, aren't boycotts protected under Claiborne? But we already saw the answer to that question, right? Again, Supreme Court ruled in NAACP versus Claiborne was a primary boycott of white-owned businesses to protest racial discrimination in Mississippi. No one disagrees with that principle, but the court, courts here have been somewhat clear that Claiborne does not prohibit, does not say that all boycott activities are protected. It didn't say that, and they're not protected. So the question is, Claiborne essentially left open, and now it's getting somewhat technical, but Claiborne left open a question, right? Claiborne affirmed that the elements of the boycott that do involve protected First Amendment activity don't lose that protection just because they're accompanied by some non-expressive elements. But it never suggested that the mere act of refusing to deal with someone constitutes inherently expressive conduct. And it didn't address whether the First Amendment protects refusals to deal that are forbidden under state anti-discrimination law, which is what we're dealing with here. At the time, by the way, it couldn't because there were no laws in Mississippi prohibiting racial discrimination. So that question, which was left open by Claiborne, was conclusively answered by the Supreme Court in a case called Rumsfeld versus Fair, which involved law schools that were engaged in a boycott of military recruiters to protest the military's don't ask, don't tell policy. So to the extent that such a boycott involves non-expressive activity, that activity is not protected. And that's where the challenges are now in their second stage. They're attempting to distinguish fair. Some of the distinctions are downright silly. So literally, there's one opinion which says, well, fair is inapplicable because the court in fair didn't use the word boycott, even though the plaintiffs referred to their own action as a boycott. And the court was describing a boycott and didn't feel the need to actually use that word. So some of the distinctions are a little more trivial. Some involve technical readings of the bill's statute. So for example, in Arkansas and again in Georgia, one of the courts chose to focus on a particular phrase in their bill's definition of boycott because it said engaging in refusals to deal with or terminating business activities with or other actions that are intended to limit commercial relations with Israel. And both of those states said, well, other actions is too broad because it could, and even though, again, the state has reiterated that the plaintiffs are free to express their feelings in any way that they want. But the court said, well, when you say other actions, someone could misread that as applying to actions that are protected under the First Amendment. If you follow regular statutory principles of how to read these statutes, it's, I think, a ridiculous claim, but that's something that's still being debated. Worst comes to worst, they'll have to amend that statute and remove those two words, other actions. But we're basically quibbling over nothing at this point.
Well, we've got an incredibly mixed audience and the questions are coming in from all over the world. But in the UK, the Conservative Party's manifesto in 2019 included a much welcomed commitment to ban public bodies from imposing their own direct or indirect boycott, divestment, or sanctions campaigns against foreign countries. And that promise was advanced in the 2019 Queen's Speech. And by the most recent Queen's Speech this year, it included a commitment to stop public bodies from imposing their own approach or views about international relations by engaging in BDS. And this is a striking difference in the motivation, it seems, behind the legislation here in the UK and in the US, where we see the focus is clearly on the discriminatory nature of BDS. Has there been a similar sense in the debates in America that sanctions policy as foreign policy should be the preserve of the government, and in the case of the United States, the federal government?
Yeah. The short answer is yes. It's long-standing policy of the United States federal government to oppose discriminatory boycotts against Israel, period. Ever since President Carter, not the biggest fan of Israel, but signed the anti-boycott amendments to the Export Administration Act in 1977, every single American Congress and administration has affirmed it. And as we saw in that Longshoreman case, we didn't do an in-depth read of it, but essentially there's no problem with regulating actions that are against United States foreign policy. The clear United States foreign policy here is not to boycott Israel. So it's somewhat consistent with the approach that the UK is taking, which is states shouldn't be deciding foreign policy themselves. To the extent that it doesn't bother other US interests, there might be a little bit more leeway. But again, the primary function of the bills nowadays focuses on anti-discrimination, but they come out of a history of federal legislation relating to the Arab League boycott, for example, and US persons participating in the economic boycotts that have a history of strong federal government support.
Well, staying with the UK very briefly, a further question remarks that the US has the advantage of a constitutional clause forbidding the hampering of trade. And the question asks, does the UK have anything similar beyond the Magna Carta clause to check how enemies are treating our merchants before dealing with theirs? I'll just remark that restraints on trade are contrary to public policy at common law here, but the UK courts have developed restricted, development of this principle in the late 19th century. It's a major failure. It's argued to be a major failure and principal cause of the UK's economic decline in the 20th century. And I should say that our chief executive, Jonathan Turner, has produced an article on a related subject, which I believe it has, we might be able to put into the chat. Thank you for that question. There are a couple related questions here that I'm going to put to you, Mark. The first is very simply, would a primary boycott against Israel be illegal to ban? And on a similar basis, there's a question that asks whether or not BDS activists might achieve more by rebranding their attempts at BDS, altering their manifesto to broaden their goals and change a secondary boycott to a primary one.
Sure. There are a few different parts to that. The first answer is, even if they were a primary boycott, it's still government speech. And so we really don't even get, we just did that for fun, but we really don't even get to that secondary leg because you're not dealing with individual speech, you're dealing with government speech. What was the second part of the question? If they were a primary boycott?
Might they be rebranded from a secondary boycott into a primary boycott and gain an advantage in that?
You know, it's hard to do for a variety of reasons. Number one, everyone knows at this point what they're doing and why. And it would be very easy for a court to see through that logic. But number two, even if they did, the doctrines that we went through very quickly, like the Ally Doctrine, for example, the tests of whether or not you'd be boycotting, again, if there's really a company that these people would be boycotting if there was no state of Israel involved, sure, yeah, they could have protection under that. But it's not the case. And I don't think anyone really could believe that they would be boycotting, SodaStream if not for quote unquote Israel. Did that answer the questions? Okay.
I certainly believe so. Turning perhaps for a moment to the practical impact of this state level legislation. I think many in our audience will be familiar with the case of Airbnb, which U-turned on its decision not to provide its services in Israeli communities beyond the Green Line. What role do you see the state level legislation having played, perhaps, for example, in that case?
Very interesting. So first of all, I should say that Airbnb claimed at the time that they weren't involved in BDS, but they certainly were boycotting Israel to a certain extent. So let's just explain what boycotting Israel does from a practical perspective. Because there are anti-BDS laws in place, boycotting Israel exposes a company to a lot of expensive challenges, right? Caving into BDS demands means you're engaging in open, because you're telling us that we're doing it for discriminatory purposes, blatant discrimination on the basis of nationality and ethnicity. So you're now, and let's go back to the previous question, you're now violating anti-boycott regulations under the 1972 Export Administration Act and the Ribicoff Amendment to the 1976 Tax Reform Act. And these involve significant administrative and criminal penalties even. In the case of Airbnb, there were immediate class action lawsuits filed against the company in Israel and unfair religious discrimination cases in the United States. But they also, on a practical level, at that point, they egregiously violate the fiduciary duties of loyalty and care that the directors of Airbnb or companies like them owe to their corporations and their shareholders, right? The duty of loyalty requires corporate decision makers to put the welfare and the best interests of the company before their own personal interests and feelings. And the duty of care requires them to consider the impact of their decisions on the company's business and prospects. So looking at it just from that perspective, boycotting Israel on a discriminatory basis is unjustified and terrible for business, right? 35 states in the US have anti-BDS legislation, in effect, barring those states from doing business with Airbnb or other companies engaged in BDS. Losing business like that in the service of a possibly unpopular, certainly controversial, likely criminal ideological stances is not part of good corporate governance or fiduciary responsibility, right? There's no conceivable shareholder interest served in acquiescing to extortion and this apparent disregard for the consequences of their actions. It's so obvious that it would be almost impossible for a director to justify the decision based on sound business judgment, which would open them up to both corporate and personal responsibility. And I think that possibly has something to do with why they reversed their decision.
Mark, thank you. A couple of questions here relating to rather well-publicized comments. Are some of the comments by Ilhan Omar and other squad members falling within anti-discrimination laws? And if so, why have they not been taken to court? But perhaps a reference to the First Amendment here for the non-American members of the audience.
Sure. The question is, why are they allowed to say their anti-Semitic statements?
Indeed, the comments that fall, this questioner asks, within anti-discrimination laws. Perhaps the answer is that in the US, they're not caught.
They're right. They haven't violated, as far as I know, any anti-discrimination laws. They have said, listen, I think Ilhan Omar, and I've said this many times, is an anti-Semite. And unfortunately, she's a smart anti-Semite in that she knows exactly when to push and how to push and to move the line a little bit at a time on what is acceptable to say in Congress. Here's the unfortunate thing. I really do believe in free speech. She has the ability to say whatever she wants. I think it's sad that the Democratic Party has not acted for the first time. Listen, a couple of weeks ago, for the first time, in direct, because of what she did, the 6 Democratic leaders in the House and the Senate put out a joint statement saying they do not agree with her. Okay, they do not agree with her. And that's very, very rare. And that's a pretty public censure of someone. I think they should do a lot more. But at the same time, I don't think they can or should stifle her free speech. I think it should be exposed as the ridiculous set of lies that it is. You know, calling Israel an apartheid state when the new government's kingsmaker was Mansour Abbas, the head of an Islamist party, is just ridiculous. And I'm waiting for her apologies on those fronts. You know, she said horrible things about her Jewish Democratic colleagues. She constantly tries to play the victim after she incites. And that's something that you have to deal with in an open democracy, is you have to expose her ideas to the light and make sure that people see that they're actually lies.
Picking up on a couple of the examples that you addressed, a question here asks, would you classify BDS as boycott to expel Matisyahu from a concert in Spain as a secondary one? Would then that kind of boycott be illegal under the South Carolina statute? And subsequent to that, what about boycotting academics?
Yes, yes, and yes. So in all of those instances, right, you didn't, unless they super hated his music, right, which at the time was very popular, they weren't actually trying to boycott him for anything he did. They were boycotting him because he refused to make a statement that he was distancing himself from the state of Israel. That was such an egregious violation that various BDS movement chapters actually said that they weren't part of that decision-making process. It was such an egregious one. But if you take any act, yes, and it would be illegal to do that in South Carolina under the bill. That's a secondary boycott that was not protected. I mean, if you look at, I don't know if you all heard about this recent case of the Philadelphia food truck, where there was a food truck festival and they decided to exclude a food truck that had Israeli food on it. That's blatant discrimination and it's not protected. As to academics, sorry, go ahead.
Well, relatedly, a further question here asks, what is the best way to handle the California dock workers who refuse to unload products from Israel?
We'll turn to that in one second. The academic thing is an important one because some of those, again, just again a little bit maybe overly technical, some of the academics work for the state of Israel, right? So if there are, for example, state-run institutions, there's a better argument, I'm not giving this as an argument, but there's a better argument to exclude them. But the vast majority of academics do not work for or in any way represent the state of Israel. And certainly even ones who do, unless there's a high-ranking government official that I'm not aware of that's also an academic, you're not boycotting them because of their academic policies, and you fall back into the allied doctrine and secondary reason doctrine. And the answer to how to deal with people who are violating the law is that there should be consequences.
Mark, thank you. There's a question here that's come in two parts. The first, are you interpreting the South Carolina legislation to prohibit financial investments? And are you interpreting it to cover indirect arrangements? So, for example, investing in a compliant fund, which then invests that cash into another fund which is not compliant, where the state has no relationship with that second fund?
The answer is it does include financial investments and it does not include secondary investments. So once you have it, and if you want to make your own business decisions, again, unless, this is an important one, I guess, unless by making the investment, for example, let's assume that that secondary fund is called the BDS fund, right? So by making that investment, you are engaging openly in BDS. But if it's just a non-compliant fund that it itself is pro-BDS, but has nothing to do with the business aspect of it, then it wouldn't be included.
And taking us back to the federal level legislation that you mentioned, and also the actions of President Carter, a questioner here asks why these laws at state level are necessary if we have already federal level legislation that's dealing with this.
Sure, there's a variety of answers, but the shortest answer I'll give you is there are loopholes around the federal laws are good for understanding what U.S. foreign policy is and how it relates to states acting against U.S. foreign policy. Clearly, the U.S. is not in favor of these boycotts, and in fact, both the Republican and Democratic parties do not support BDS. That being said, the federal laws are mostly aimed at other sovereign states, right? So the Arab League boycott, for example, promoted by a variety of Arab states. The state legislation is a little bit broader because what BDS did is they called it a civil society call, so that it's a grounds up, groundswelling, grassroots organization, not connected officially to any state. Now, set aside the fact that there are a variety of state sponsors to a certain extent, but you could theoretically get around the federal laws by saying this is not a boycott organized by a foreign entity as such. Mark Goldfeder has argued that that's not true and that a careful reading of the foreign boycott statutes would apply here, but the BDS bills are sort of playing it safe, but again, taking seriously the argument and applying anti-discrimination law instead of anti-boycott law.
Well, thank you, Mark. It's been the most incredible hour, and we've got through a substantial amount of the questions. But apologies to anyone who we've not quite managed to to address directly, although I'm grateful that a number of your questions were certainly overlapping. There's been a final UK-related inquiry on how we can translate this into UK law, where and what we can do to support anti-BDS in the UK. Well, ladies and gentlemen, I mentioned the manifesto promises and those commitments that were made in the most recent Queen's speeches, the most two recent. That legislation is underway, but please take the initiative of writing to your members of parliament and encouraging them to support this initiative and to make sure that this legislation is passed in a manner in which it will have teeth and will have an important effect on preventing public authorities from conducting their own foreign policy and international relations and encouraging and engaging in boycotts with Israel. But Professor Mark Goldfeder, thank you ever so much for taking us through the situation in the US. We've had a lot of individuals joining from the United States and some great specific questions on legislation and clearly case law that they are very familiar with. So thank you very much indeed for taking the time to join us.
My pleasure. Thanks for having me.
See you again soon.